Good morning, ladies and gentlemen. Welcome to the HCCH Asia Pacific Week 2023 and welcome to our day 3 of the conference. It's so good to see you again. I'm your host, Emilia Sun, and a very warm welcome to all of our guests joining us in person and joining us online. Thank you. A very good morning to you all. Welcome. Ladies and gentlemen, since we are celebrating HCCH's 130th anniversary this year and having this conference to be one of the special events organized for the celebration, we'd like to express our gratitude to the Department of Justice of Hong Kong SAR and the Faculty of Law of the University of Hong Kong for your generous support for this 4-day conference. And also, we are very grateful for the wonderful work that our outstanding students ambassadors have been doing. Thank you for your engagement. And of course, a very warm welcome to all of our guests who've traveled to Hong Kong and joining us online to be one of the part of this wonderful conference. So moving on to today's sessions, the theme of the first 3 sessions is transnational litigation and legal cooperation. Our first session of the day will focus on the 2005 Choice of Court Convention. And we are very pleased to have esteemed speakers joining us on stage and online. So first, let's welcome Professor Jian Wenluo from the School of Law, Sun Yat-sen University, People's Republic of China, to join us on stage. Welcome. And let's welcome Associate Professor Afifa Kusumandara from the Faculty of Law, Brawijaya University, Indonesia. Welcome to join us for the panel. And online, we have Professor Gyu-ho Lee from the School of Law of Chun'an University, Republic of Korea. So we will begin with an introductory presentation by Professor Jian Wenluo. Let's welcome Professor Luo to the podium. Professor Luo, Professor Luo, please.
Okay. Dear Mr. Berlusconi, distinguished guests, ladies and gentlemen, good morning. First of all, I would like to thank the HCCH for inviting me to participate in this wonderful conference as guest speaker. It's my great honor to be here with you to celebrate the HCCH 130th anniversary. Happy birthday, HCCH. According to the arrangement of the conference, I will give a brief introduction to the Convention on Choice of Court Agreements and share my views. Which one? Oh, this one. Okay, this one. Okay. This convention is adopted on the basis of hard negotiations and compromise in the 1999 Hague Draft Convention, when it's planned to adopt a double convention containing both direct and indirect jurisdictions. It's the result of the HCCH's remitting efforts to recognize and enforce judgment through the unification of the jurisdiction of all countries. It was adopted in 2005 and entered into the force in 2015, with the intention of partially achieving global governance on the recognition and the enforcement of judgments. China signed the convention in 2017 and then faced the issue of domestic ratifications. As we all know, the ratification and the accession of the New York Convention guaranteed that China have a relatively uniform standards in the judicial review of international commercial awards, and also guaranteed the transnational recognition and enforcement of international commercial awards. The sign of this convention, to some extent has challenged the exclusive advantage of international commercial arbitration in the settlement of international disputes. The formal signing of the convention by China shows that China, as a responsible major country with the policy of opening up, is also an important action for China to participate in international relations, governance, and in the construction of a new international civil and commercial order. At present, the European Union, Mexico, Singapore, Denmark, and other countries have become parties to this convention due to the ratification of the convention. The United States, Ukraine, and other countries, including China, have signed the contract. The importance and the influence of this convention are emerging. And it has also attracted more and more attention from all over the world. As an agreement jurisdiction convention at the international community level, this convention plays an important role in improving Chinese agreement jurisdiction system. For example, the 2006 agreement is the internationalization of the convention. Furthermore, the recent revision of the civil procedure law of China has been heavily influenced by the convention. So let's see the content of this convention, the main content. The preamble of this convention is basically remained consistent with the 2019 Judgment Convention, which emphasized the importance of strengthened judicial cooperation, and that such cooperation could be strengthened by unifying the rules on civil and commercial jurisdiction and governing the recognition and enforcement of foreign judgments. Here. The convention has 5 chapters and 34 articles. As we see, there are 5 chapters, and it mainly embodies the following 3 basic principles, which are the trial obligation of the chosen court. The second one is refusal obligation of the court not chosen. And the third one is the obligation to recognize and enforce the judgments made by the courts of the contracting states. Yes. Sorry. The first chapter is scope and definition, consists of 4 articles, mainly stipulating scope, exclusion from scope, exclusive choice of court agreement, and other definition. The rule of implied exclusive jurisdiction is a key point in this convention. At the beginning of the establishment of the convention, it intended to set international uniform rules for the exclusive choice of court agreement. So the draft of the convention before its adoption in 2005 added the attribute exclusive before every choice of court agreement. After the former adoption of the convention, Article 22 provides the contracting states may apply the convention to a non-exclusive choice of court agreement through a declaration of reciprocity, which is the main reason why exclusive was removed from the title of the convention. However, Article 1A still provided that the choice of court agreement to which this convention applied is an exclusive choice of court agreement. Article 3B of the convention defined exclusive as a choice of court agreement which designates the courts of one contracting states or one or more specific courts of one contracting states shall be deemed to be exclusive unless the parties have expressly provided otherwise. The convention provisions on exclusivity are general, and there is no dispute if the parties expressly state that the agreement is exclusive. However, if the parties only designate courts, whether the agreement is exclusive or not need to be judged by the domestic law of the contracting state. The validity of the agreement depends on the applicable law stimulating in the agreement. However, the nature of choice of court agreement is similar to the dispute resolution clause in the contract. According to the severability of the dispute resolution clause, the validity of the choice of court agreement is not affected by that of the main contract. Moreover, decision of foreign courts may be recognized and enforced by the courts of other countries only if they obey the exclusive jurisdiction of other countries' courts. Therefore, Article 2B of the Convention excludes 16 special matters from the scope of application, most of which involved the scope of the exclusive jurisdiction of states, such as emergency rescue at sea and the intellectual property infringement. An effective choice of court agreement is the prerequisite for the court to exercise jurisdiction. Through interim measures of the protection are not governed by the Convention, it does not restrict the parties and the choice of court agreement. Chapter 2 of the Convention mainly stipulates the jurisdiction of the chosen court and the obligations of the non-chosen court, clarified the effect of the exclusive choice of court agreement, and applies the law of the chosen forum. Article 5 of the Convention says the court or courts of a contracting state designated in an exclusive choice of court agreement shall have jurisdiction to decide a dispute to which the agreement applies, unless the agreement is null and void under the law of the state. This is an exception to the implied exclusive jurisdiction of the chosen court, which means the chosen court does not own exclusive jurisdiction if it's invalid under the domestic law. The core of this article is the definition and understanding of the law of that state and its impact on this determination of the validity of jurisdiction under Chinese law. From the text of the Convention, the report and the discussion submitted by the representative of states during the negotiations, it's clear that the law of that state means the domestic law of the chosen court state, including the conflict norms. The invalidation is limited to the defects of substantive elements such as fraud, error, and insufficient contracting capacity, but excludes the defects of formal elements like written form. When judging the validity of the choice of court agreement, the Convention aimed to emphasize the authenticity of the parties' will accordingly to the substantive law of the chosen court state, while internationally dilute the negative impact of the procedural law, so as to avoid the invalidity caused by the procedural law of the chosen court state, which fails to the purpose of the party's choice. Article 6 of the Convention provides that a court of contracting states other than that of the chosen court shall suspend or dismiss the proceeding to which an exclusive choice of court agreement applies. The principle of chosen court jurisdiction stipulated in Article 5 and Article 6 is intended to reach a greatest possible consensus between the chosen court and other contracting state court outside the chosen court on issue of effectiveness of jurisdiction agreements. This is to avoid parallel proceedings resulting from the inconsistent recognition of effectiveness of the choice of court agreement, thereby fulfilling the Convention's purpose of enhancing jurisdiction certainty. As to the validity of the choice of court agreement or jurisdiction agreements, the Convention does not clearly clarify it as a procedural or substantive issues. It neither adopts the traditional approach of procedural matter according to the law of the court, nor does it apply as a contractual matters under the law governing the contract. In order to highlight the independence of jurisdictional agreements, the Convention allows to contracting parties capacity issues to be governed by the law of the firm, like the EU's Brussels regulations. The key rule in Chapter 3 of the Convention is the recognition and enforcement of judgments. Article 8 of the Convention says, a judgment given by a court of a contracting state designated in an exclusive choice of court agreement shall be recognized and enforced in other contracting states in accordance with this chapter. Recognition or enforcement may be refused only on the ground specified in this convention. Article 9 of the convention lists 7 grounds for refusal of recognition and enforcement. Among these, there are 2 aspects of concern. Firstly, the understanding and efforts of public policy. Regarding public policy, Article 9(5) of the Convention provides that recognition or enforcement would be manifestly incompatible with the public policy of the request state, including situations where the specific proceedings leading to the judgment were incompatible with fundamental principle of procedural fairness of the state, whether it's public policy, reservation of the public policy, or social public interests. The Convention cannot, and indeed did not, specify its connotation and denotation. There is no fixed standards for the understanding and application of the public policy in each state, as it changed with time, conditions, and other factors. Therefore, it's still uncertain how Chinese court will interpret and will impact it may have on the convention in practice. Secondly, where the conflicting judgments conflict with the premise of exclusive jurisdiction. With respect to conflicting judgments, Article 9(6) of the Convention provides that the judgment is inconsistent with a judgment given in the requested state in a dispute between the same parties. This seems to be contradicted. The premise of the judgments made by contracting states courts designed designate in an exclusive jurisdiction agreement shall be recognized and enforced. According to the explanatory report, the conflicting judgments here refer to judgments where the parties are the same, but the course of action need not to be the same, including situations where the court is misled into rendering a period judgments due to the absence of the other parties. Therefore, it does not conflict with the premise of exclusive jurisdiction. Here too, the requested state may refuse to recognize and enforce the foreign judgment. The Convention essentially gives priority to the judgments of the request state courts and excluding the first state court approach. Article 10 of the Convention stipulated the circumstance of refusing recognition and enforcement due to the preliminary questions. Article 11 provides from the scope of the recognition and enforcement of awards damages. Because of many types of damages, it often leads to a large differences in the amount of compensation in the judgment. The fourth chapter of the Convention is general clause. A total of 11 articles, accounting of 35% of the total number of articles of the Convention. The content are mainly about how to resolve the practical problems that may be faced in the application of the Convention, of which the core is the provision of Article 19 and to 22 on the declaration of limitation of that the state may make. The last chapter of the Convention is final clauses, which is mainly about the procedural issues concerning the accession, validation, and the denunciation of the contract. In conclusion, the purpose of this convention is to promote a free movement of judgments and make the result of litigations more predictable, reducing the cost of cross-border commercial transaction. Signing the convention produced a more sufficient legal basis of the recognition and enforcement of judgments of the contracting states. It also played a positive role in strengthening international judicial cooperation and promoting economic exchange and trade development. The improvement of the rule of law in matter involving foreign parties in China could not be separated with the positive influence of the legislative concept and the system of the convention. We should constantly strengthen the discussion of the design of the convention, further improve the system of foreign related law and regulations, and construct the legal system of the new open economy. Thank you.
Thank you.
I'm so sorry because I'm not so well today. So sorry for my um, not so well performance. Sorry.
Well, thank you so much for joining us still. Thank you. Would you like to join the Q&A session later, or would you like to? Okay. Thank you. Thank you very much for engagement. Thank you very much for the introduction of 2005 Choice of Court Convention. Now, ladies and gentlemen, let's move on to talk about the regional perspectives. And can we invite Professor Gyuho Lee online to speak first? Now, let's give him a very warm virtual welcome. Hello, Dr. Lee. Hello, Professor Lee. You can hear us, right?
Okay, I can.
Thank you. So the stage is yours, please.
Okay. So my name is Gyo Lee, working at the Chungang University in Seoul, South Korea. Uh, I'm serving. Okay. Yes, I'm serving as the editor-in-chief in the Korean Yearbook of International Law. I'm a member of the Korea Copyright Commission. I'm the vice president of the Korea Private International Law Association. So, okay, this is my privilege to participate in this wonderful conference. This is the second time, I guess. I want to show some of the elements and points I want to make in terms of the choice of a court, the convention from the perspective of Korean scholars. W here means is the weakness of this convention. So basically the number of contracting party to the convention is 33 as of the April 28th of this year. The Singapore is the only one country which is ratified this convention in Asia. The South Korea did not sign yet, even though there are so many strong support from the academicians in Korea. So another weak point of this convention is related to the scope of this convention. For example, consumer under the Article 42 of the Korea Private International Law refers to passive consumer, not the active consumer. In this context, passive consumer is defined. Consumers enter into a contract with another for the purpose of other than the occupational or business activities. So many users in the internet or the metaverse are classified as a consumer under the Article 42 and Article 47 of the Korean Private International Law. It means they are not subject to the choice of court conventions. That's the weakness of this convention. So also another weak point is that it doesn't cover the employment contract. Also, it did not cover the validity of intellectual property rights other than the copyright and the related rights. It means it didn't cover the validity of industrial property rights. Also, it did not cover infringement of intellectual property rights other than the copyright and related right, unless those are the arising out of the breach of contract. So so far under the case law, prior to the amendment of the Korean Private International Law in 2000, 2022. It held that an exclusive choice of court agreement is valid if the following requirements are met. Those requirements are as follows. The dispute case is not subject to the exclusive jurisdiction of the court of foreign country. And the Korean court must have jurisdiction of the case. Next, the case has a reasonable connection with the Korean courts. Actually, it doesn't require, the convention does not require these elements. And the exclusive choice of court agreement must not constitute a legal act that is remarkably unreasonable and unfair, which is contrary to the public morals. This is a strong points of this convention because the Korean private international law of 2022 definitely is in line with the gist of the choice of code conventions. So this amended new law provides detailed rules on the international jurisdictions, taking into account the choice of code convention, even though Korea is not the contracting parties to the convention. So, under Article 8 of the Korean Private International Law, choice of court agreement is presumed to be exclusive. Also, writing by electronic means is allowed. This is the most important things. It does not require the reasonable connection anymore between the disputed case and the Korean courts. So I skip this part. So, and a choice of court agreement shall be in writing, include the electronic expression of a person's intent exchanged by telegraph, fax, email, or other means of communications. As I said, the international jurisdiction based on the agreement between the parties is presumed to be exclusive. Also, the choice of a court agreement that forms part of contract shall be treated as an agreement independent of the other terms of contract. If there is an agreement that an action may be filed exclusively with the courts of the foreign country in terms of a particular legal relationship between the parties, a Korean court must dismiss the case unless the following conditions are met. Okay, now to move on to the law applicable validity of exclusive choice of court agreement. This shows some kind of opportunity the Korean legal community just to jump into the choice of court conventions. According to the previous Korean case law, that law must be applicable law is tax 40. But under Article 8, Section 1 of the Korean Private International Law of 2022, the applicable law is the law country where the court chosen by the parties is located. It means definitely a new law of the 2022 followed the approach made by the choice court conventions, Article 5. So the new law of the 2022 prescribes list pendants. So this is a very tricky issues I have. It has something to do with recognition and enforcement of foreign judgment. It can be opportunity or a threat to the Korean legal community. Those issues are two things. One is can we allow the punitive damages or excessive damages? Also, another thing is related to extraterritorial application of injunctions issued by the court of a foreign country. So, Article 217 of the Korean Civil Procedure Act prescribes the recognition of foreign country judgment, especially Article 217 bis of the Korean Civil Code, Civil Procedure Act prescribes where final judgment, etc., on compensation for damages give rise to the result being markedly against the basic order of the Act of the Republic of Korea or international treaties entered into by the Republic of Korea, a court shall not approve the whole or part of the relevant final judgment, etc. So this is a very the opposite case here. And the former case, the Korean Supreme Court in the 2015 held that the punitive damages or excessive damages exceeding compensation or damages will not be recognized. This court has said punitive damages or excessive damages are contrary to the public morals of Korea. But on the other hand, the Korean Supreme Court on the March 11th, 2022, held that treble damages up to 3 times of compensatory damages are not the contrary to the public morals of Korea, where the increased damages under certain laws purports to fully compensate the infringed damages. So this court held Hawaiian court's judgment was recognized in the field of competition law, in particular with respect to the Act of the Fair Transactions and in the subcontract transactions which prescribes travel damages. Actually, I interpreted, the increased damages in a certain area, including the industrial property law. Some of the industrial property law dispute will be covered by the court of the choice of court conventions. So I interpreted increased damages such as there is travel damages as compensatory damages. However, other professors, some of the Korean legal community interpreted. This is all I have today. If you have further questions.
And gentlemen, thank you for attending my presentation. In my presentation, I will discuss first the benefits from acceding to the Choice of Court Convention for Indonesia. Second, challenges of implementing the convention in Indonesia. And finally, the steps that must be taken to implement the convention in Indonesia. The benefits of the Choice of Court Convention for Indonesia are, among others, first, the courts of Indonesian civil procedure do not oblige the parties to comply with their choice of court agreements. The 2 codes that were enacted by the Dutch colonial government provides that the principle of actor sequitur forum rei may prevail over the choice of court agreement, depending on the plaintiff's choice. For example, in the case of PT Indah Kiat Pulp versus Bank America National Trust Company et alia in 2008, the parties agreed to the courts of New York State as their choice of court and agreed to the laws of the state of New York. However, the Indonesian company Indah Kiat brought the parties' dispute to the Bengkalis District Court in Indonesia, although the same dispute was still pending in the New York court. The Bengkalis court exercised its jurisdiction on the ground that some of the collaterals were situated in Bengkalis. In extraordinary appeal, the Indonesian Supreme Court did not invalidate the jurisdiction of the Bengkalis Court, although it annulled its decision because Bengkalis Court applied the wrong law. This decision, made by Indonesian courts, has lowered foreign investors' confidence in the Indonesian legal system. The second benefit of the Convention for Indonesia is that the draft bill of Indonesian private international law that recognizes the jurisdiction of courts chosen by the parties cannot be expected to become law anytime soon. Therefore, the accession to the Choice of Court Convention may help enforce the parties' choice of court agreements in Indonesia. Another benefit of the convention is that it will convince foreign parties about legal certainty in Indonesia and efficient dispute settlement with Indonesian companies, as it is common that Indonesian parties make choice of court agreements with their foreign counterparts. Finally, the Indonesian government itself, in particular the Ministry of Law and Ministry of Foreign Affairs, are not against the idea of establishing international agreements with other states to recognize and enforce the judgments of foreign courts chosen by the parties, insofar as the courts have their seats in the states that are parties to the international agreements. However, there are also some challenges to the convention in Indonesia. Currently, it is not easy for the government to accede to international treaties in general. The amended constitution requires Indonesian president to obtain approval from the parliament when entering into international agreements that can affect the state's budget. The choice of court convention, in my opinion, may fit the category of an international agreement that can affect Indonesia's state budget. That is because a judgment made by a court of another contracting state that is chosen by the parties may harm Indonesian enterprises, especially the state-owned enterprises whose assets and capital come from the state budget. Therefore, the accession to the convention requires approval from the parliament, which is not an easy process. The constitutional requirement did not exist when Indonesian government acceded to the New York Convention 1958, for example. Therefore, it was easier for the military government in 1981 to accede to the New York Convention 1958 only by virtue of a presidential decree. Although, in fact, the New York Convention posed the same risk of loss to the Indonesian state-owned enterprises due to foreign arbitral awards. The second challenge is that the choice of court convention may cause exodus of cases from Indonesian jurisdiction to foreign courts because, in practice, foreign parties often choose foreign fora, either foreign courts or foreign arbitration in their agreements with Indonesian parties. That can cause resentment among Indonesian judges who want to maintain their judicial authority and refuse to become merely enforcers of foreign judgments. That happened back in 1981 after Indonesia's accession to the New York Convention 1958, Indonesian Supreme Court refused to enforce foreign arbitral awards for 9 years and ordered lower courts to do the same. At that time, foreign arbitral awards were not self-executing and must be reviewed by the Supreme Court in order to protect Indonesia's interests. To face the challenges to the choice of court in convention, Indonesia must take the following steps. First is to make Indonesian courts favorable for foreign parties, to convince them to choose Indonesian courts instead of foreign courts in their contracts with Indonesian parties. Meaning that Indonesia must improve the low quality of its judicial process caused by the lengthy and costly process of enforcing contracts in Indonesia, as indicated in the 2020 World Bank's Ease of Doing Business Index. Next, the Parliament must be convinced that the choice of court convention can improve Indonesia's ease of doing business, or it is called now Business Ready Index, that is useful for Indonesian economy. In addition, the government must make necessary declarations provided by the convention to safeguard Indonesia's interests. Along with the choice of court convention, the government needs to accede to the 1970 Evidence Convention and 1965 Service Convention. The two conventions provide more efficient mechanism for Indonesian courts when serving judicial documents to and taking evidences from the parties abroad. Therefore, the accession to the Evidence Convention and Service Convention is important to support the implementation of the Choice of Court Convention in Indonesia. Thank you for your attention.
Thank you very much, Professor Kusumandara. Please have a seat. And we'd like to thank Professor Law for attendance today. Thank you very much. All right, ladies and gentlemen, now is our very interactive session. We're going to have some Q&As. So please feel free to just raise your hands if you have any questions for either of our panelists on stage and join us online. Just feel free to ask your questions. And of course, our online guests, you can just type your questions through the Zoom through the Zoom chat feature. Thank you very much. So can I see?
As a functional alternative for the traditional punitive damages so that it can be acceptable in many other contexts. And I think excluding multiple damages, the multiplied part of the multiple damages from the concept of what was the compensatory damages should be a point where there should be an international consensus and about which there should be an uniform interpretation of the 2005 and 2019 conventions. And I'm wondering if Korea deviates from the broadly shared understanding of what compensatory damages, non-compensatory damages mean, then there will be a problem about the uniform interpretation or generally uniformity of private international law. I'm also a bit cautious about making reservation, because reservation should be supported by a strong state interest. And I'm wondering if, well, if the multiple damages, the multiplied part of the multiple damages.
First of all, you have the two questions, and it's about uniform interpretations by the international community, legal community, need to be made in the field of whether it is punitive or not. The second question is reservation the clause need to be very cautiously adopted. Otherwise, it doesn't fit into the international convention. So first of all, I want to start with the scope of this convention because in Korea, more than the 15 the acts prescribes travel damages. Even the Automobile Management Act contained what is it, 5 times the damages, but the most of all travel damages they're prescribed. And at first, at the outset, actually those acts start to cover competition law areas. Also, that covers neighbor related the acts. So those areas actually it can be excluded the scope of the convention. But I actually object to this kind of movement in Korea because it is punitive in nature. But it starts to include intellectual property law area. So in this sense, I think the infringement of intellectual property rights, the rising out of the breach of the contract will be covered by this convention. So this is nothing to do with the discrepancy of the bargaining power between the consumer and the producers or the labor, the users and employee and the employers. So in that sense, definitely uniform interpretation is needed, necessary. Another thing is, I didn't say the word reservation. I just used the word declaration. So we can go into the declaration, said this increased damage is not characterized punitive. So in this sense, we can just fit into the what is it, the approach made by this convention. That's my answer. Thank you.
Thank you, Professor Lee, and also thank you, Professor Junyu Zhang, for your question. So do we have one more question? Anybody? Okay, that gentleman there.
Okay, yes. My question is for Professor Kusumandara.
Kusumandara.
So as a practitioner in Hong Kong, we do have clients who have operations in Indonesia, and we are drafting contracts for them. It's actually very natural for us to say, hey, let's use Hong Kong law, because number one, we theoretically and practically can't advise on foreign law. But at the same time, with the power of the conventions, we know that it might be beneficial to use local law as well. So what are the advice you would have for international practitioners to encourage people to say, hey, let's use other forum so as to resolve some of the challenges you mentioned about the exodus of cases and all that? What would you teach us Hong Kong practitioners on how to promote these conventions?
Very practical question, please.
Thank you for your question. Thank you. Thank you for your question. Actually, I myself is not a practitioner, but I see from the theoretical and then academic point of view, when I read many judgments of Indonesian courts up to Indonesian Supreme Courts, it is really still the big issue, you know. In majority of the cases, Indonesian courts would like to try, and if because of the principle of actor sequitur forum rei. So let's say you have Indonesian counterparts in your agreement or contracts. And then the Indonesian parties bring the case to Indonesian courts. And most of the time, it is the trick for Indonesian parties for the cases to be accepted by Indonesian courts is that the contract issue is converted into the tort issue. So if it is tort, usually Indonesian courts will take it, particularly if the case or they claim, the Indonesian parties claim that the tort takes place in Indonesia. Although actually it is based on contracts, but they say that because the contract is made based on fraud, for example, so it becomes tort. And it makes the Indonesian courts feel obliged. So actually, for example, in the case of the Indah Kiat that I just gave you the presentation, so there are the Indonesian courts, not only the lowest one, the Bengkalis one, but also the High Court and then up to the Supreme Court, use so many reasons, legal reasons, to make the case, even it was still pending in New York, to be tried in Indonesia. So I think the biggest problem of this chaotic situation is that Indonesia does not yet have the act of private international law. We already submitted the draft bill many times since 1983. I do not know why, but Indonesian parliaments prefer to pass legislation that relates to public law. This, even we do have private law that still derived from the Dutch because it's private law. While public matters like criminal codes, etc., it has been amended recently. So in my opinion, once again, actually HCCH conventions are faster to improve the situation in Indonesian private international law in general. Like for example, now we ratified or acceded to Apostille Convention and others. And we think as well, actually, instead of choice of court convention, the ministers, the ministries that I mentioned earlier, Minister of Law as well as Minister of Foreign Affairs, actually now work very hard to convince the government to accede to the Service Convention and Taking Evidence Convention, because these two conventions do not affect, let's say, do not affect the state's budget. It is just procedural. So hopefully the government could just issue the government regulation or presidential decree, like in the case of Apostille. But choice of court convention, I think it is important, but once again, in my research, because I'm writing an article about this, there is, you know, a refusal from the courts because they are afraid that the cases will be taken by foreign courts. So they lost their judicial authority given by Indonesian constitution. So I think the background of all this chaotic situation is that because there is no yet the codified Indonesian private international law. I hope I could answer your question.
Thank you very much. I believe it's very clear and thorough explanation. Thank you. Thank you for addressing this question. And that's it for our Q&A session. We'd like to say goodbye to Professor Lee joining us online. Thank you for your time. And thank you, Professor Kusumandara. Thank you. Thank you for our panelists. Thank you. Please return to your seat. Thank you. So now, ladies and gentlemen, let's proceed to our next Singapore Academy of Law, Singapore. And firstly, let's welcome Mr. Simon Kwan to deliver the introductory presentation on the 1961 Apostille Convention. Let's welcome him to the podium.
Dr. Pesciconi, Professor Gao Escola, distinguished guests, ladies and gentlemen. Good morning. Welcome to Hong Kong. If this is your first time to visit us here, if this is not your first time, welcome back to Hong Kong. It is my honor to join you in celebrating this week the 130th anniversaries of the HCCH. I also thank you for the HCCH for inviting me to take part in their Asia Pacific Week 2023 conference held in Hong Kong SAR for the in-depth experience exchanges with the government officials, experts, legal practitioners, and stakeholders from the Asia Pacific regions and other parts of the world. This week, we heard a number of distinguished speakers, including Dr. Pesciconi, who mentioned about the Apostille Conventions. It is described as the most successful conventions, most popular, and mostly used. In particular, for 2023, it's also a remarkable year for the Apostille Conventions. As we learned, China has been a member of the HCCH since 1987. On the 8th of March 2023, China acceded to the 1961 Apostille Conventions, which will enter into force this year on the 7th of November 2023. It will obviously simplify the use of public documents abroad and expedite international trade. Perhaps I will give an overview of the conventions. The long title of the conventions is the Convention Abolishing the Requirements of Legalizations for Foreign Public Documents. We commonly refer the convention as the Apostille Conventions, which was put on the agenda for the 9th sessions of the Hague Conference on Private International Law in October 1960s, well before I was born, and was first signed on the 5th of October 1961. In 2021, we celebrate the 60th anniversaries of the conventions, when a special commission was held, online webinar, to mark such occasions. I attended that occasions also. The Apostille Conventions basically abolished the legalization process and simplified the authentications of public documents for international use. As of June 2023, we have 125 states being contracting states of the conventions. For the conventions, of course, as a trained lawyer and also as a judge, we will see the wordings of the conventions. It contains 15 articles. Of course, I will not go into details of each of the articles for the purpose of today. These are contained in this book or else on the website. In particular, I would recommend those competent authorities, users of the convention, to read, again, this is on website, the Apostille Handbook. This is a very useful, handy, contain almost all the wisdom, intelligence of experts in attending the previous special commissions and eventually gather their wisdom and write into this handbook. Of course, the most updated version was written and updated this year after the last special commissions adopting the revisions. So that most of the questions that you may wish to ask in the Q&A could be found in the answer in this book. So, what is an apostille? An apostille is the certificate issued under Article 3.1 of the Conventions to certify the authenticities of the origins of a public document. The effect of an apostille is certifying the authenticities of the signatures on the documents and the capacity in which the person signing the documents, but not the contents of the documents. In the past, without the Apostles' Conventions, we need to run through a very cumbersome legalization process, running through local registry, Ministry of Justice, and then go to the Ministry of Foreign Affairs and also the consulate of the designating countries. So you can see this particular diagram. This is also coming up from the handbook so that I acknowledge the source of it. So you see, this is a very long-winded, cumbersome process. It may take months. As I was told, sometimes it may take years to complete a document. And it would be very expensive also. Recently, I was told in one country whereby they need to run through the legalizations of a will so that it could take effect in Hong Kong. It takes years, and it costs more than $100,000. So, Hong Kong dollars. So, before it could come to Hong Kong, it takes a long process. If that country is a contracting party, as I learned, this country is, this year, the contracting countries, Canada. So, it would simplify the whole process. It would save all the monies. And then the will can be proved in Hong Kong more quickly. So the apostille process. Firstly, the public documents are executed by the government department, agency in the state of the origin. Then the competent authorities verifies the authenticities of the public documents, issues the apostilles. The apostilled public documents can then be produced to the state of designations and can be verified by the recipient. So, you may hear a number of references about public documents. So what is a public document? Any documents executed by an authority or person in an official capacity is a public document. This comprises a broad range of documents, including the categories of documents listed in Article 1.2 of the Apostles' Conventions. If a document was subject to legalization before the entry into force of the convention, it is likely to be the public document. under the conventions. There could be a lot of examples of public documents. Usually, those documents issued by government departments. In Hong Kong, there may be company registry, land registry, birth and death registry, or else those certificate, notary certificate signed by the notaries or the commissioner for oath. Of course, there can be many, many other examples of public documents. Again, if you want to see, read the handbook. The handbook has a very, I may say, comprehensive descriptions about public documents. Of course, they ask us, the state of the origin, to have a more liberal, generous interpretation as to what amounts to a public document, so that it could benefit more user to produce the documents for apostilles. Under the conventions, once you sign the conventions, you have to nominate a competent authorities. So what is the role of the competent authorities? When joining the conventions, a contracting parties must designate the authorities that are competent to issue apostilles. That is Article 6. Each contracting parties is free to determine the identity, the number of its competent authorities. Under the conventions, they perform three fundamental functions: verifying the authenticities, origins of the public documents, issuing the apostilles if the authority is satisfied of the origins of the documents, and finally, recording the issues apostilles in their register to facilitate verifications of an apostille requested by a recipient. Under the conventions, they provide a model apostille certificate in French and English. Again, the special commissions would recommend contracting parties to have bilingual certificate, if possible. Here is the model apostille certificate. Each apostilles will bear the title, apostilles, and have 10 numbered standard informational items. In order to facilitate the circulations of the public document internationally, we have to ensure that the apostilles issued by the contracting states are easily recognized by all other states. The model apostille certificate should be followed as closely as possible by the competent authorities. So I don't know whether you will see the items, the 10 items there. So these are the items which we recommend each contracting state in the apostille certificate to contain. Out of these boxes, you can add anything. I would describe how the Hong Kong certificate adds something onto the model apostille certificate. And then I would like to include for this presentations the e-apostilles program. Have some, I may say, mention about that. The e-apps, what we usually call, was launched in 2006 to promote and assist in the implementation of technologies under the Apostilles Conventions. So although the convention is quite old, but we have modern technologies to build it. So there is new elements to this ancient conventions. There are now 41 contracting states having implemented one or both the e-app components, either the e-apostilles or the e-registered. So under this particular program, sorry, I have mentioned this slide. So we would have, under the conventions, both the paper apostilles and for those states with e-apps program, the e-apostilles also. So when a public document is executed in paper form, and apostilles will be issued by attaching a stickers or a stamp on it. For e-apostilles, instead of issuing a physical certificate, the competent authority generates a digital certificate that is electronically attached to the document or stored in a secure database. The electronic apostilles contain all the necessary information to verify the authenticities of the document, including digital signatures and unique identifiers. There are benefits of applying e-apostilles. It simplifies authentications and legalization process. It reduces administrative work. It enhances securities and efficiencies of document verifications. And finally, it will be easily transmitted and verified online, facilitating faster and more convenient cross-border transactions. And the second component of the e-apps programs is the e-registered. And e-registered can be used to record the issuance of both paper apostilles and e-apostilles. This allowed any interested persons to verify the apostilles online. Only the recipient of an apostilles has the information required to access and use the e-register to verify an apostilles issued by the competent authorities. So what are the benefits of using the e-registered? The e-register encourages quick and easy verification of apostilles. The process does not require staff to manually respond to inquiries regarding issue apostilles, and the records can be retained with the entries remaining active and easily accessible for as long as possible. So hopefully, if your computer is not being hacked or somehow corrupted, it could contain all the issue apostilles information forever and ever. One of the, of course, important features in the conventions is how monitoring the practical operations of the conventions permanent bureau. The success of the conventions cannot be achieved without the support of the permanent bureau. The permanent bureau is, of course, we know the secretariat of the HCCH. It conducts and coordinates activities aimed at promoting, supporting the practical operation of the conventions. It responds to queries from contracting parties concerning applications of conventions, conducts missions to advise on effective implementation and operations of the conventions, and prepared and organized meetings of special commissions and the e-apps forum. I must thank for all the excellent work of Dr. Basconi and his dedicated team of staff of the permanent bureaus. We have quite frequent e-apps forums held. It had been held for 12 occasions in 11 locations, which are organized by the Permanent Bureau. Regular meetings are organized to provide an opportunity to exchange information and experience in the e-apps and the practical operations of the components. It has proven useful for discussions of matters such as electronic notarizations and digital authentications. As I have mentioned, the success of the conventions also relied upon the meetings at the special commissions. The convention's general performance is monitored by periodic meetings of the special commissions to review the practical operations of many of its core conventions, adopting conclusions and recommendations aimed at promoting best practices and improving their operations. So far for the Apostles' Conventions, special commission meetings have been held in 2003, 2009, 2012, 2016, and lastly, 2021. I would recommend those of you who may not have the chance to attend the commissions, do take the opportunity to attend the special commissions. It's a great experience. I myself attended the special commission in 2009. It's quite a challenging 2 weeks meetings. Of course, not just the Apostles' Convention. In that year, we have 4 conventions with the special commissions held within 2 weeks' time. I think after that, it seems it changed the format to have the special commissions for each conventions to be held within a period of time. It's a great experience, as I said, and we will have the chance to visit the Peace Palace in The Hague. And also, I think the environment of The Hague is really a good time for you to see the operations of the HCCH. I was learned that there will be coming special commissions, but not on this Apostle Convention, which was only held in 2021. There will be special commission in the coming years. Next month. Oh, all right. So stay online to see whether you will have the chance to attend the special commissions. How the Apostles' Conventions impact on interconnected world. So in an interconnected world where cross-border interaction is increasingly common, the impact of apostles is significant. It can enhance legal certainties. The apostles provide legal certainties to document use abroad. It ensures that the documents have been issued by the appropriate authority and has not been tampered with. It would also facilitate international trade. The apostles would simplify the authentications of public documents and would eliminate the need of additional layers of authentications and promote smoother trade relations. And also, it would enhance cross-border collaborations. The apostles ease the exchange of documents necessary for cooperation in the areas such as research and professional qualifications. To conclude, the apostles has a profound impact in an interconnected world by simplifying document authentications. Its widespread adoption has significantly contributed to the efficiency of the cross-border transactions and interaction in today's globalized societies. Pardon me if I can spend the last part of my speech for a few minutes to talk about the implementation of the apostles in the Hong Kong SAR. The Hong Kong became a member of the Hague Apostle Conventions on the 25th of April, 1965. Together with a number of other Hague conventions, they continue to apply to Hong Kong after its handover to China in 1997. For Hong Kong, the competent authorities of the Apostles' Conventions contain a number of persons, but only my post, I issue the apostles for the present moments. So I'm the principal officer who signed the apostles in Hong Kong. You will see my signatures on all the Hong Kong apostles. So that I have these signatures known to the world. So here are the usual kind of documents which Hong Kong SAR has issued apostles. You will see the most commonly used are those certificates issued by the notary public, 60%. And then Commissioner for Oath and other government organizations such as company registration document, birth and death certificate, marriage certificate, business registration certificate, and others. As I mentioned, we have our own sample apostille certificate. It is in a bilingual apostilles. You will see it is issued in English and Chinese. And you will see on top, this is not a compulsory part, but as I understand, this is a recommendation in one of the special commissions, is to alert those users of the apostilles that we are not verifying the contents of the documents, only the signatures. This part is an optional one, but we accept the recommendation of the special commission and act on top of it so that every person know what is the principal objectives of the apostilles. Of course, you see my signature there and the court seal there. So our apostilles is quite widely accepted. I was told one of it is because of our court seal. And the number of apostilles issues, we can see from 2018, which only have about 54,000, up to last year, more than 100,000. We will expect the increasing trend for 2023. So it will pose challenge, but it will also mean why I said the Apostille Convention is the most successful, most popular, and mostly used. So this is demonstrated in Hong Kong. And lastly, I would like to say the use of the e-register. This is coming from our judiciary website, so that if you want to verify an issued apostille, you can verify under our e-register. So Hong Kong, we are now having a e-register, the second component of the e-app program. So this particular e-register is available at the judiciary website. It enabled and interested parties to verify the issuance of an apostille in the Hong Kong SAR on or after the 1st of September 2014. And the number of users of the e-register in Hong Kong SAR has increased from, in 2018, only 562, by last year, 2,400 odds. I have to, this is really my final part, to report to the audience that the judiciaries of the Hong Kong SAR has gone through the preliminary feasibility studies of establishing an e-apostille system in Hong Kong. And we'll continue to discuss the details with our main stakeholders, the notary publics, since they dominate the mostly used apostilles, paper apostille at the present moment. I hope after a fruitful discussions with the stakeholders, we may implement the e-apostille system later this year or early next year. I hope by then I can report to Dr. Besconi that Hong Kong will have the full e-apps program. Thank you very much.
Thank you. A big hand to Mr. Kwan. Thank you. Very beautiful signature, I must say. Thank you very much for your introduction. Now let's move on to the regional perspectives. May we first invite Ms. Miranda Pastrana to the podium, please. Thank you.
Okay, Dr. Bernasconi, Dr. Go Escalar, fellow panelists, ladies and gentlemen, good morning. Thank you very much for inviting me today to share our experience in discharging our role as the competent authority for the Philippines for the Apostille Convention. This year, the push for digitalization of government processes and transactions in the Philippines is stronger than ever, with the current administration directing our ICT agency to fast-track e-government initiatives. The Department of Foreign Affairs, as you can see, recently signed a memorandum of agreement with the Department of ICT on the digital transformation of our consular services, including the apostille by 2024. The Philippines acceded to the convention in September 2019, and it entered into force on May 14, 2019. The convention is vital to millions of Filipinos who are doing business, working, residing, investing, and studying in all parts of the globe. The Philippines currently has one competent authority, and that is the Department of Foreign Affairs Office of Consular Affairs Authentication Division. Since 2019, we have issued more than almost 2 million apostilles. The exact figure is 1,930,468. So we average around 500,000 documents every year. A key highlight of the Philippine apostille, of course, is the operation of an e-register, which we call the apostille verification system. The e-register is particularly useful to us since we encounter cases of fraudulent documents. So through this system, anyone can check the issuance of the Philippine apostille online. So to verify a Philippine apostille, all you have to do is enter the apostille number and the key code, then a complete image of the apostille will appear on your screen. We cannot overemphasize enough how helpful this system is to us in verifying apostilles for the end user, since we issue hundreds of thousands of apostilles every year. So the division recently received a delegation from the Thai Ministry of Justice and Foreign Affairs and the Embassy of Pakistan and shared our experience in implementing the Apostille Convention. Of course, we touted the benefits of having an e-register when they implement their own apostille system. So as you can see there, we also did a tour of how we conduct our operations. Oh, sorry, that's not the this is the Thai and Pakistan delegations that we hosted. So we also continued to coordinate with partner government agencies to resolve pressing issues on authenticating public documents, and one coordination meeting we had this year involved the Supreme Court Office of Court Administrator, headed by the Honorable Raul Villanueva, who is also a panelist in today's conference. We are still working on our full transition to the e-apostille program in cooperation with the Department of ICT and the Philippine Statistics Authority, and we hope to do that by next year. We plan to pilot test civil registry documents, since 40% of our apostilles are actually civil registry documents. And since the Philippine Statistics Authority also has an existing system for the issuance of the e-certificates. So some of the challenges we have encountered even before we implemented the Apostille Convention is the proliferation of document fraud. So the e-register or online verification of the apostille is one of the key measures which has greatly hampered the spread of fake public documents in the Philippines, since receiving parties are now able to verify the apostilles that they receive online. Another challenge is the lack of a nationwide delivery system, so our services are limited to select areas in various regions, and applicants have to travel to those areas to obtain an apostille. We're currently in the process of integrating a courier system in our apostille issuance system. Of course, our transition to the e-apostille system will also resolve this challenge. So lack of resources and personnel, this is a perennial challenge for government services. This adds to the difficulty of the way we forecast our targets and maximize client access to our services. Our transition to the e-apostille will also resolve some of these resource needs. So we also have been constantly improving our capacity building and certification program. We're working with government partners in strengthening the capacity of our personnel in the implementation of the Apostille Convention. We recently engaged the assistance of our law enforcement agencies in strengthening the capacity of our personnel in forensic document examination. The first line of defense for us is equipping our personnel with the right tools in fraud detection, since that is one of our challenges. So to curtail and prevent fraud, we are also closely coordinating with law enforcement agencies such as our police force, the National Privacy Commission, and the National Bureau of Immigration in reporting cases of fraud. We also initiated a fraud prevention strategy and fraud response policy to counteract the spread of fake public documents and tampered apostilles, which we have encountered, by the way. So we recently issued a public advisory on our zero tolerance policy for falsified or tampered documents for apostille, and we penalized certain representatives or agents caught submitting fake certificates and referred them to law enforcement agencies for investigation. We actually noticed some changes in the application since we issued this advisory. So we also continue to work with our DFA offices in engaging with certain EU countries on the withdrawal of their objections to the Philippine accession to the Apostille Convention. We're very happy to note that Austria has withdrawn its objection to our accession, and diplomatic legalization for all Philippine apostilles issued on or after June 1, 2023 is no longer required for it to have legal effect in Austria. And I hope the other 3 countries will follow suit. So as practitioners in carrying out the operational aspects of the Apostille Convention, we truly see and feel the significant benefits that this convention has on the lives of many individuals, business owners, investors, students, people on the ground who are dealing with cross-border situations and transactions. And that concludes my presentation. Thank you for your attention.
Thank you. Thank you very much, Ms. Miranda Pastrana. Thank you. Thank you very much. Now, continuing talking about the regional perspectives, let's invite Mr. Paul Neal to the podium. Welcome.
A very good morning to Secretary General Bernasconi, Deputy Secgen Go Escolar, Registrar Simon Kwang, esteemed speakers and participants both here and online. On behalf of the Singapore Academy of Law, I would first like to thank the HCCH ROAP, the Hong Kong Department of Justice, and HKU Law for this opportunity to share our experience so far in operationalizing the Apostille Convention in Singapore. The convention entered into force in Singapore almost 2 years ago, on 16 September 2021. Our Ministry of Law is the policy owner for matters relating to the convention, while the Singapore Academy of Law, which is a statutory body headed by our Chief Justice and the judiciary, is the appointed competent authority overseeing the practical operation of the convention for Singapore. Singapore's journey towards accession spanned about 5 years and began with a joint mission by SAL and our Ministry of Law colleagues to attend the 2016 Special Commission on the Practical Operation of the Apostille Convention in The Hague as observers, where we first met Dr. Bernasconi, who even back then was already plugging for us to implement the EAPP, though we didn't need much convincing as we shared his vision for digitalizing the legalization process. As the national agency that appoints notaries and commissioners for oaths, and having the responsibility to authenticate notarized private documents, SAL had the duty to secure the integrity and improve the efficiency of the legalization framework in Singapore, and we were looking at employing digital technologies to do so. We undertook extensive consultations with the notarial and business communities, and also with our colleagues from the Consular Division of our Foreign Affairs Ministry, who surprised us back then by confiding that they preferred to transfer the public document legalization function to SAL as well. And so we seized the opportunity to tackle the issues of consolidating, securing, and bringing up to date the document legalization and notarization regime in Singapore at one go, basically to transform the entire legalization landscape. Our plan was to deploy a digital platform for legalization that was independent of the work involved in accession, but to ensure that this platform would be apostille-ready. As a common law jurisdiction, we followed up with study visits to the United Kingdom's Legalization Directorate in their Foreign and Commonwealth Office, and also here to Hong Kong, where we met the Hong Kong Office of the Registrar, and we were very warmly welcomed by Master Jack Wong and his colleagues, who gave us an immensely helpful sharing of Hong Kong's experience in implementing the e-register. In fact, we were so impressed by the efficiency of the back-end operations we witnessed that we even purchased the same model of printer for the apostille stickers. The Australian and New Zealand College of Notaries also held their 2018 convention in Singapore, and we took the opportunity to consult them as well. So armed with the generous sharing of our foreign counterparts and stakeholder feedback, we began system development in October 2018, and our online legalization platform, which we called, not too creatively, the e-register, was launched a year later in October 2019. Now, during this time, in November 2018, the issue of accession into the convention was raised in our parliament, and with the IT infrastructure already under development, Singapore was firmly on the path to accession at last. When the bill for accession to the convention was eventually moved in Parliament in November of 2020, the questions raised concerned costs, the scope of verification, process digitalization, e-register security measures, and steps to prevent apostille fraud. By this time, our e-register had already been in service for a year, and I suppose this helped our law minister to address those questions relating to digitalization and security. As to cost, the original fee of 10 Singapore dollars before tax for legalization was maintained for apostilles as well. And so with the all-important assurance that costs for the public will not increase, the bill for our Apostille Act was passed within 25 minutes. Portions of Singapore's Apostille Act, such as the definition of what constitutes a public document, are drawn from the HCCH's Apostille Convention text. So under the Act, SAL is mandated to legalize documents issued by Singapore courts and government agencies, private documents that have been notarized by our appointed notaries, and commercial documents certified by our chambers of commerce. I'll now touch on how we have approached the EAPP. In Singapore's case, the e-register component of the EAPP serves as a one-stop platform to handle all matters relating to document notarization and legalization. The platform caters to both consumers and providers of legalization services. In Singapore, only senior lawyers may apply to become notaries, and this platform serves as the application portal as well as the digital workbench for appointed notaries to complete their notarizations. Within the e-register, there are templated jurats for notaries to use, and it also features mandatory online payment, which frees our counter staff from having to collect payment and enabling a quicker turnaround of about 30 seconds per customer on average. Use of the e-register by appointed notaries is mandatory, and only they have access to the platform's workbench functions. Notaries can only generate a notarial certificate through the workbench, and apostilles will only be issued for notarial certificates generated this way. So this enhances the security of our legalization process. For members of the public, the e-register caters to their private and public document legalization needs by providing educational information on legalization, a directory of notaries to contact, and also allows for appointment booking and payment, as mentioned earlier. Apostilles are generated via the e-register upon presentation of the public document or notarized private document at our counters. Singapore's paper apostille comes in the form of an A5 size tamper-proof sticker. And to our Hong Kong audience, if this looks familiar, no prizes for guessing why. And it also has a red certification seal affixed to the back of the document. As you can see, we also got the idea of incorporating the caveat at the top of our apostille from Hong Kong, so thank you. The apostilles also carry a QR code which takes users to a mobile-friendly verification page, and users will have to enter the apostille number and a unique verification code to obtain confirmation of the valid issuance of the apostille. At that time, in anticipation of our accession into the convention, the e-register had been designed to conform to the Category 2 standard under the EAPP. Decentralization of legalization services via our e-register makes it logical for a single-track legalization process to be adopted in Singapore. This means we issue apostilles for all outbound legalized documents, regardless of the receiving party's convention status. The advantage of a single-track legalization process is that we don't have to constantly monitor and update the list of contracting states, especially since the Permanent Bureau does such a great job of constantly expanding the list. And also, it extends the benefits of the e-register's online verification feature to recipients in non-contracting states. And this brings me to one of the first challenges we encountered in implementing the convention. Despite efforts to provide advance notice of this change to the foreign missions based in Singapore via third-party notices issued by our Ministry of Foreign Affairs, the consular staff at some, not all, but some, local embassies apparently did not get the message and rejected the single-track legalization document or apostilles we issued. So we had to engage the few holdouts one-on-one, and fortunately we were able to compromise on just adding the legalization stamp alongside the apostille as shown in the photo. The majority of the local missions of non-contracting states in Singapore, however, were okay to accept our apostilles. In terms of internal challenges, the biggest was to get our notarial community on board our digital transformation effort. This wasn't strictly speaking a challenge pertaining to the convention itself, but more a product of Singapore's plan to overhaul the legalization regime whilst operationalizing the convention. So to prepare the notarial community for the digital transformation of legalization in Singapore, we conducted close to 40 training sessions on the use of the e-register over a 2-month period for over 700 notaries, and we continue to provide technical support to this day. Apart from skills upgrading, these sessions also proved to be a valuable community building exercise, and we found it much easier to communicate changes and engage with our notaries since then, and they are also much more open to giving feedback now. Today, about 20% of all apostilles we issue are for government documents, while 80% are for notarized documents, and I understand this is quite similar for Hong Kong. The 3 types of legalizations performed are for certification of true copies, true signature, and true document. For physical documents, it takes our counter staff less than a minute on average to process each transaction, and we are aiming to reduce this drastically for electronic documents, as I'll explain this later. To date, we have issued over 300,000 apostilles via our e-register since the convention came into force about 2 years ago, with 55% of the total bound for contracting parties, among which China is the top destination. Of course, with Malaysia and perhaps Thailand soon to become contracting states, we can expect the pie on the left to grow further. Looking ahead, Singapore is on track to begin issuing e-apostilles next year, in addition to paper apostilles, as the number of public documents issued only in electronic form continues to grow. We plan to do this in 2 phases. In the first phase, to cover only electronic public documents, and in the second phase, to include notarized private documents, first for in-person notarizations, and then for those done remotely. Even for a tiny country like Singapore, the benefits of a fully virtual legalization process culminating in the issuance of an e-apostille became stark during the height of the COVID pandemic and border closures, when demand for legalizations spiked. So the queue shown in the earlier photo is despite that 30-second turnaround time I mentioned. To enable a fully virtual end-to-end process, we have promulgated remote attestation procedures for our notaries via practice guidelines, following the passage of legislative amendments to our Oaths and Declarations Act earlier this year. On the use of blockchain technology, which is already employed for certain public documents like our academic and vaccination certificates, our National Agency for Digitalization of Government Services, GovTech, has developed an open source DLT-based framework called Open Attestation, or OA, which will be the national standard for verifiable digital documents issued by all government agencies. Thus, Singapore's e-apostille will also be in the OA format, and we are currently in the process of both UX design and database integration with our government agencies, especially those who are responsible for over half of the documents coming for legalization today. We've branded documents in the OA format as Trust Docs, and they are designed to be easy to access, easy to share, and easy to verify. They are also easy to track, and we will be able to know where the documents are used, how many times they are produced or opened, etc. The OA standard will also automatically make our e-register Category 3 compliant, as the underlying legalized document will also be shown within the OA package, thereby increasing transparency. The OA format also affords greater control, as it has the potential to allow for location and duration validity to be set if required. Looking back, our journey towards operationalizing the Apostille Convention was greatly helped by the generous sharing of our common law counterparts in the UK, Hong Kong, Australia, and New Zealand. And we are also grateful to the Permanent Bureau for its steadfast support throughout the operationalization process. Having benefited from such help, it was our privilege to pay it forwards by sharing our own experience with our neighbors from Malaysia who visited last year to study our e-register system and operations. And we look forward to hosting Thailand's Director of Legalization, who will be visiting Singapore later this month. So in conclusion, the fact that the Apostille Convention is the most widely adopted of all the Hague Conventions is concrete proof of the recognition of its benefits by many countries around the world. For us in Singapore, it has also been leveraged as a catalyst for the digitalization of our legalization regime and landscape. To this end, we are grateful to the Permanent Bureau and fellow contracting parties for the fruitful discussions at the Experts Working Group on EAPP and New Technologies, and we look forward to continuing discussions on data standards and information exchange. Thank you.
Thank you, Mr. Paul Neil, for a great discussion. Thank you, and thank you to our panelists for a great discussion, for insightful discussion. Thank you very much. And ladies and gentlemen, due to the limited time we have in hand, shall we continue the discussions and conversations during the coffee break downstairs? Thank you very much. Let's give it up for our panelists. Thank you. Okay, all right. Let's say we have a 15-minute short break. All right, thank you. So we will see you all back at 12. Thank you very much. Didn't starve yourself too much because we're gonna have a real lunch in less than an hour, okay? Ladies and gentlemen, welcome back. Without further ado, let's start our next session, which we will delve into the 1965 Service Convention and 1960 Evidence Convention. So joining us online is Mr. Brody Warren, Assistant Director of the Private International and Commercial Law Section at the Attorney General's Department of Australia. Mr. Warren will deliver an introductory presentation. And also, let's welcome our two esteemed speakers to join us on stage. Let's welcome the Honorable Raul B. Villanueva, Court Administrator of the Supreme Court of the Philippines. Welcome to join the panel. And Ms. Van Ho Hung, Department of International Law at the Ministry of Justice of Vietnam. Welcome to join the panel. All right, welcome. Please have a seat on the stage. Well, firstly, let's say hello to Mr. Brody Warren. Hello, welcome to join this discussion. Hello, Mr. Brody. Hello, can you hear us?
Yes, I can hear you. Can you hear me okay?
Yes. So please, Mr. Warren, please deliver the introductory presentation, and the stage is yours.
Great. Thank you very much. Good afternoon, everyone. It's a pleasure to be joining you for Asia Pacific Week 2023. It's wonderful to see many familiar faces there in the room, albeit from afar, coming together to celebrate the 130th anniversary of the HCCH. Before I begin my presentation, I would like to thank the entire organising team at the HCCH, including the Regional Office for Asia and the Pacific, as well as, of course, the additional support, the generous support from the Department of Justice of the Government of the Hong Kong Special Administrative Region of the People's Republic of China, and the Faculty of Law at Hong Kong University. I'm joining you today from the city of Sydney on the lands of the Gadigal people, and I would like to begin by acknowledging them as the custodians of these lands that I'm on today, and pay my respects to their elders past and present, and recognise their continuing connection to the land and the waterways, as well as their contributions to the community as part of the oldest continuing cultures in the world. While my presentation is an introduction to the conventions, I wanted to just give you a brief overview first of our team and our role within the Attorney General's Department here in Australia, and how it relates to the implementation of the HCCH Service and Evidence Conventions in particular. So to give you a snapshot, our section, as you mentioned in the introduction just now, is the Private International and Commercial Law section. We have 3 teams within that section, and that includes the Private International Law team, of course, the one I'm speaking from today, as well as our bankruptcy team and personal property securities team. In terms of the role of the Private International Law team specifically, we have kind of 3 main aspects of our role, and that includes the international engagement, of course, as the HCCH national organ, in addition to following the work of the United Nations Commission for International Trade Law, as well as the International Institute for the Unification of Private Law, UNIDROIT. A second main role is having policy responsibility, kind of more of a domestic aspect of our role, meaning that we look after specific laws that implement private international law treaties and instruments domestically in Australian law, or other Australian laws that relate to conflict of laws aspects within Australia as well. The third aspect of the role is part of links quite relevantly to what we'll be discussing today, but that is the role as the HCCH Central Authority under the Service and Evidence Conventions, and also a couple of relevant bilateral treaties as well. So that just gives you, I guess, the context in which we work within our team. In terms of our casework specifically, we are party to a number of bilateral treaties in addition to, of course, the HCCH Service and Evidence Conventions. So our role is as central authority to receive these requests, primarily reviewing them and forwarding them on to the relevant Australian states and territories for execution. And that's kind of the nature of our federal system as well, the way that the implementation in Australia is primarily through state and territory legislation and the court rules in the states and territories. So I guess in some respects, the progress and finalisation of requests is significantly driven by the processes of our states and territories, particularly given that service often has to be effected in person and with a hard copy at this stage. And I'll come back to the technological aspects of the convention a little bit later. But in terms of the way we operate, that's the primary mechanism, I suppose. For us, I suppose I put a few figures there just from the last financial year for us in terms of the overarching number of requests that we've received, as well as the number that were finalised or closed in that time as well. I guess you can see there, sorry, I should have said that those figures refer specifically to the HCCH Convention because under the Service and Evidence Conventions, they make up the bulk of the requests that we receive, and as well as then an additional few, I suppose, under specifically the bilateral agreements that we have with Korea, the Republic of Korea, I should say, and Kingdom of Thailand. So the only other thing to note there is just to say that this excludes requests that are directly sent to our states and territories. That is because in each state and territory we also have them designated as additional authorities under each of the Service and Evidence Conventions, which I guess we'll come back to a little bit later. In terms of, I guess, the overarching purpose or the intention of the Service and Evidence Conventions, conveniently they both kind of have very similar goals, and some of which you might kind of sense a theme from the other conventions and I guess the purpose of the organisation that you've heard about earlier in the week. But essentially from our perspective as well, the Service and Evidence Conventions are looking to simplify and expedite the procedures for serving documents and taking evidence abroad. They do provide this means to overcome the differences between legal systems as well, which is an important part for us, also being a country from the common law tradition, in particular with dealing with countries from the civil law tradition and other systems, essentially non-common law systems. In addition, I suppose part of that is to respect the diversity of these legal systems and the substantive laws and procedures, of course. In terms of overarching purpose, I suppose it then goes without saying in some ways that the intention is to facilitate international legal cooperation and improve the provision of mutual legal assistance. Of course, there are times when there are delays, and we have seen a number of delays. I think us, like many countries, experienced a number of setbacks during the pandemic because of the hard copy processing primarily. But I guess I'm pleased to say that we are kind of working on with our states and territories as well in terms of improving those processing times for us too. In terms of the status of the Service Convention, as you'll see there, you've got 82 contracting parties. You may have already heard this earlier in the week in terms of an introduction, but it has been a busy year, I suppose, for the Service Convention, with Azerbaijan and Paraguay joining, and of course in the Asia-Pacific region, Singapore. So we're looking forward to continuing our cooperation with Singapore under the Service Convention. And yeah, I suppose there's still work to be done, but it's been great to see that increase in numbers of parties to the convention more recently as well. In terms of the scope of the convention, I guess there are four main elements, and here, if we think back to the official name or the full name of the convention, is looking about the transmission of documents for service abroad. So in that sense, there are some aspects of the convention, of course, that deal almost directly with service, but in most cases, the primary mechanism is what we're talking about, is transmitting documents from one contracting party to another for the purpose of service. The second aspect is that in terms of scope, it applies only to judicial and extrajudicial documents. The third being that it should be in a civil or commercial matter. that's, I guess, fairly self-explanatory, but primarily excluding criminal matters and things like that, which often are dealt with under other treaties, of course, and mutual legal assistance internationally. And then fourthly, this interesting kind of aspect of the convention in terms of the fact that the addressee or the person upon whom the documents are to be served, their address has to be known. So there has been some, I guess, conversation over the years around this between different states and different systems. For us, that is quite important that the address is complete as well. Unfortunately, we don't have a system where we're able to locate citizens in terms of registration procedures like some countries do. So for us, the address is actually a very important part, and also, as you may have gathered, it does help us direct requests to the appropriate state or territory authority in our jurisdictions as well. In terms of the operation, I guess this is sort of an overarching mechanism. I realise that in the time available today, we may not be able to go into a great deal of detail about all the mechanisms of the convention, but essentially this is an overarching framework. We have kind of the main channel of transmission, and that involves a central authority. There is a required model form, and then it also has a certificate of service, which actually kind of facilitates that the proof that the documents were actually served in the requested state. There are a number of alternative channels as well, which is kind of the overarching term that we use in the Service Convention to talk about the flexibility aspect as well, in terms of having different options other than the main channel. So it preserves some of the mechanisms that were already in existence, including diplomatic and consular channels, the regular post, as well as direct communication in terms of between judicial officers, bailiffs, or competent persons in different countries, depending on the legal system as well. And then finally, there are the derogatory channels, which I mentioned earlier, that we have a couple of bilateral agreements as well. So that just kind of preserves that mechanism. Multilateral agreements, for example, the inclusion of the European service regulation or things like that as well. So it could be either bilateral or multilateral, but it does, the Service Convention does kind of preserve that flexibility there as well. In terms of the main channel of transmission, I've sort of tried to simplify it here, but essentially in practice what happens is that there is a request that's drawn up and it must be in accordance with the model form that's annexed to the original convention. The format has changed slightly over time, but essentially the substance is the same. And those are available from the HCCH, but many central authorities like us provide links on our websites and things like that. Essentially, there is a forwarding authority, is the term used in the convention, but that essentially is just the authority that is competent in the requesting state to send the request abroad. So that's determined by the law of the requesting state. And then that authority essentially transmits the request directly to the central authority, which is designated under the convention to receive those requests. And as I mentioned, we are the central authority in Australia, and often it is some kind of Ministry of Justice, perhaps a court or Department of Justice or equivalent in many countries. And then it is the responsibility of the central authority to either serve the documents themselves, if that's within their competence, or alternatively arrange for the documents to be served, which is sort of in our case that we forward it to the relevant competent authority in Australia. And then finally, once service is effected, as I mentioned, there is that aspect that the certificate of service is required to be completed and sent back. For us, this often includes something like an affidavit of service from the bailiff, and then the relevant state or territory authority completes a certificate to go with that under the convention to just confirm that service has been effected, in our case, conforming with Australian requirements, and that then can be used as kind of proof of service for the purpose of the foreign proceedings. In terms of the other alternative and derogatory channels, I guess I can kind of quickly cover a couple of these, but essentially looking at the diplomatic and consular channels that I mentioned, preserving the postal channel, so the freedom to send documents by post for the purpose of service, if that is permitted by the legal system or the relevant legal systems, and the direct communication between judicial officers. I have noted there that a contracting state can object to the use of these alternative channels, so it's quite important there. In the case of the derogatory channels, again, sort of just a number of ways to preserve the flexibility of mechanisms that exist. And I think I'll probably leave it there for now, but I'd be happy to answer any questions on that one, so that we can just cover the evidence commissions all of the time available. So the same kind of thing here. I think that you'll notice a slightly lower number of contracting parties, but nonetheless a growing number. And we this year welcomed El Salvador and Paraguay to the Evidence Convention. So that's good news, particularly for the Latin American and Caribbean regions. But again, yeah, you can see the contracting parties there on screen. In terms of the operation, it's I've kind of tried to structure it there in the same way that there are different mechanisms, but they are ultimately the mechanisms provided under the convention. There is the main one, which is kind of in evidence convention terminology known as Chapter 1, and then what is the equivalent in some ways of the alternative channels under the Service Convention is Chapter 2 in the Evidence Convention, and then there are also derogatory channels, just as we had for the Service Convention as well. In terms of the letters of request, or Chapter 1 of the Convention, you'll notice that it's quite similar to the Service Convention in the sense that there is a request. There is a model form under the Evidence Convention, but it's not required to be used. It is only kind of recommended, so a lot of states in practice do use it. In terms of the transmission, the authority that transmits has to be a judicial authority under the Evidence Convention instead of leaving it to it is still left, I suppose, to the law of the requesting state, but it must be a judicial authority of some sort. And then, of course, as with the Service Convention, the request is transmitted to the central authority, and then the evidence is taken, and whether that evidence is, once the evidence is obtained, then it's returned to the requesting authority. There are a couple of specifics here, I guess in terms of scope primarily, but looking at civil and commercial matters, I guess we have discussed that in terms of the overarching convention. The request can be for the taking of evidence or the performance of another judicial act, and that's kind of allows some scope for what is permitted under the relevant laws. In terms of the request itself, it has to be in relation to judicial proceedings that are commenced or contemplated. So it can be before they're formally commenced, but there needs to be some kind of nexus or connection to the fact that there will be proceedings. The convention does allow for the assistance or use of compulsion, but again, it respects the different laws that are applied, in particular looking at the requested states' relevant laws. And there is an aspect of the convention where it allows contracting states to object to the use of evidence requests or letters of request for the purpose of pre-trial discovery of documents. So that's why I put that asterisk there, just to note that some countries have made declarations that they won't accept requests for those. In practice, many countries are happy to do so as long as it's not a kind of general request for any and all documents. It's kind of more a specifically outlined request in practice. On the execution of a Chapter 1 or a letter of request, it is the internal law of the requested state. So say for us, we're incoming requests, we then obviously execute under Australian laws and procedures. That said, if there is what's called a special method or procedure, so specific requests that are made by foreign requesting authorities, that under the convention must be kind of complied with to the extent that it is not, I guess, incompatible or contrary to our own laws, or impossible of performance in terms of perhaps a practical reason or limitation or restriction in that sense. There are different rules, but essentially the rules around the presence of parties and representatives is generally permitted. The presence of judicial personnel of the foreign of requesting authority is subject to whether or not there's a declaration by the relevant state. And there are quite specific grounds of refusal in the convention. So looking at whether or not it's outside of the functions of the judiciary that's executing the request. So sometimes it just may not be possible given the way that the laws work in the requested state. And then the other ground of refusal is looking at something that might, if execution might prejudice the sovereignty or security of the requested state. So just to cover, I guess, the other mechanisms in the Convention, looking at Chapter 2, or kind of the equivalent of the alternative channels for the Service Convention. There is, again, a request for taking evidence abroad. Here we're talking about the court of origin rather than the requesting judicial authority, but it's essentially the same kind of thing. It's just Chapter 2 terminology. That the court of origin then arranges for either the appointment of a commissioner to take evidence abroad, or for a consul or diplomatic agent, essentially, to, on behalf of the court of origin, take evidence abroad. There are nuances here in terms of permission that are specific to each of those mechanisms under the Convention, and whether or not the person to be examined is a citizen or a national of the state of origin. But in practice, I think that just to note that in some cases, permission of the state of execution might be required here. But essentially, this allows the flexibility of where it is permitted that the court of origin can essentially directly take the evidence under using their own laws and procedures to the extent that they're not contrary to those of the state of execution. I should note here that the entirety of Chapter 2 is subject to potential objections by the state of execution, and that's whether it can be kind of the whole of Chapter 2 or part of Chapter 2 in terms of which of those mechanisms. So it's a good idea if you are planning to use any of these in terms of litigation or something like that, or a dispute or taking evidence, to just check the relevant declarations of the state in which you are planning to take that evidence. In terms of specifics, again, same sort of thing in terms of scope, civil or commercial matters. There is a kind of broad remit for all kinds of evidence that, as I said, are not contrary to the law of the state of execution. Here, it has to be to do with judicial proceedings that have commenced. It cannot be the contemplated aspect of Chapter 1, but there's just that distinction there with Chapter 2. And there is the possibility to apply for assistance by compulsion, and that's dealt with under the Convention as well. And I suppose there, just to say that there are the derogatory channels, and it does allow kind of, for example, the internal law or practice, if permitted, performance of any of the mechanisms or taking evidence under the Convention on less restrictive conditions. So that's, again, preserving that kind of flexibility while providing the other mechanisms that are already in the Convention. Just a quick note before I finish up, I suppose, on the use of technology. I mentioned that in our case, a lot of requests are still received in hard copy, but increasingly there are some requests that are transmitted electronically, sort of by email. I note that there are even a couple of countries that have exclusively online submission of requests now as well. But Australia is not at that point. We do still receive majority by mail, but to note that there is a distinction between, I guess, the transmission of a request through email, for example, and then printing it out so that it can be served. So just the transmission is electronic, or ultimately the execution of the request in terms of effecting service or actually taking the evidence electronically. So effecting service electronically can happen in a couple of countries in the world, but I think mostly many countries still use the personal service. And then execution of an evidence request, for example, might take place by video link or video conference in some circumstances too. And just to say that the Convention is kind of technology neutral in that respect. And so that's why that flexibility has still been preserved even in the modern age. So I guess to conclude here, I suppose just to note that by joining the Service or Evidence Conventions, it does replace the need for negotiating multiple bilateral agreements, so access to that kind of global network in most cases. The Evidence Convention does have a slightly different procedure by which acceptance of accessions is required, but again, still access to that network is the important aspect. There is the streamlining of procedures, particularly when the legal systems are different between the civil law and common law countries, particularly. But the primary benefit is also the reduction of the time frame in terms of no longer needing to use diplomatic channels as well. So it does alleviate some of the pressure on officials at consular posts and diplomatic posts around the world. And that goes for Australia as well, certainly. in terms of the legal certainty and predictability, it does provide that framework to have a set number of clear options that assist courts and parties when planning either litigation or to affect service or take evidence, while preserving that flexibility to choose between the options, and for states to kind of protect their own interests by declaring or objecting to certain mechanisms where necessary. And then, of course, the final thing is the added benefit of the post-convention work, which I'm sure you've heard about earlier in the week, but facilitated for the most part by the Secretariat, the Permanent Bureau, including through the publication of guides and handbooks, which I know we use at our central authority quite a bit as well. But most importantly, perhaps the meetings of contracting parties that occur to discuss the operation of the conventions, which are called special commissions, the next one of which, as I understand, will be held in mid-2024. So we're looking forward to engaging with other countries ahead of that one and through the special commission as well. I think I'll leave it there for now, but I would be very happy to answer any questions that you may have. Otherwise, I just thank you again for your attention.
Thank you. Thank you very much. Thank you, Mr. Warren, and we look forward to seeing you in person next time. Please stay with us for the Q&A session after this panel. Thank you very much for the wonderful introduction. And now let's move on to share some regional perspectives. So firstly, let's have Mr. Villanueva to join us in the podium. Welcome.
Thank you so much, Emilia. A blessed day to everyone. Ni hao. Hello. First, of course, allow me to make my greetings, and then hopefully, because insofar as some of the listed speakers from the Philippines are concerned, they might decide eventually to just adopt my greetings later on, if they decide to do so. Anyway, first, of course, is I think Emilia deserves a round of applause. So far, her hosting is impeccable for the past 2.5 days. Anyway, my greetings as well, although he's not around, Secretary General Dr. Christoph Bernasconi of the HCCH, and of course, the lovely Deputy Secretary General Geraldine Go Escolar, who is present here right now. My shout out as well to the regional office of the Asia Pacific, headed by Professor Yun Zhao, supported by Levi Gao and Alex Nang. Likewise, the Philippine delegation, headed by the embodiment of brains and beauty, who belongs to the highest, who is a member of the highest court of the Philippines, from the Supreme Court, the Honorable Ami Lazaro Javier, who is with us. Of course, with her is likewise a presenter for tomorrow, a former trial court judge, now a member of the Appellate Court, the Court of Appeals of the Philippines, the Honorable Gigi Kimpo-Sale, who is also here. I'd like to also greet all the lawyers, brilliant lawyers, top-notch lawyers from the offices of the different associate justices of the Supreme Court who are here. They were chosen because of their expertise and, of course, their knowledge and their interest insofar as private international law is concerned. Likewise, may I just thank the Hong Kong Special Administrative Region and Mainland China insofar as their support to this activity or Asia Pacific Week 2023 is concerned. I am a believer of the one country, two system policy that they are observing. Finally, of course, congratulations to the HCCH for 130 years of connecting, protecting, cooperating through effective multilateralism. So with that, I hope that will not be included in the time allotted to me. So let me now proceed. This is not the best time to make a presentation. This is between our time with, of course, my partner here, Ms. Hung Pham from Vietnam, is between after coffee break and before lunchtime. So hopefully you still have the energy, to listen to all of us. Of course, Mr. Brody Warren, last year I remember when we also, when we had this Manila Forum of the HCCH, he was also the one who gave the introduction regarding the Service Convention and the Evidence Convention. So let me start with, by holding this and then, okay. Oh. Which one? This one, okay. By starting with, of course, the relevant constitutional provisions, the Philippines relating to international law. Of course, the Philippine Constitution, we adhere and adopt the generally accepted principles of international law as part of the law of the land. However, when it comes to treaties or international agreements wherein conventions from of the HCCH are included, these require, of course, concurrence by at least 2/3 of all the members of the Senate. Excuse me. But take note, insofar as succeeding to the conventions are concerned, this is also the function of our executive branch, particularly by our president. The moment that the president agrees to sign and accede to the agreement, we can actually accede already as well with respect to the conventions that are, of course, included in the HCCH list of core private international laws. But take note as well, insofar as the role of the judiciary or the Philippine judiciary is concerned, the judiciary is, of course, as in all jurisdictions, is a separate branch of government vested with judicial power that can check possible abuses from both the two other branches of our government. But there is a major feature insofar as our judiciary is concerned, and that is the power to promulgate rules provided for in Section 5 of Article 8. Why is this very important? Because, we have a very proactive Supreme Court, so this exclusive rulemaking power becomes vital when it comes to the exercise of judicial discretion and, of course, in the efficient administration of justice, whether for stakeholders in our country or even abroad, or living abroad within, of course, the confines of our territorial jurisdiction. Of course, we know, as echoed already by Secretary General Bernasconi, the HCCC is, of course, an intergovernmental organization that is mandated to ensure the progressive unification of the rules of private international law. And as presented by him several days ago, he mentioned that in essence, the HCCH builds bridges to facilitate cross-border interactions with little impact on domestic law. So we note for a fact that insofar as the Philippines is concerned, among the major regions of the HCCH in Europe, Americas, Asia Pacific, and Africa, we belong, of course, to the Asia Pacific region, and we have acceded to at least 5 conventions, mainly on the 2 core conventions of the HCCH, which are one on international family and child protection law, and second, with respect to transnational litigation and apostille. We have yet to come up with, we have yet to accede to some conventions pertaining to international, commercial, digital, and financial law. Now, let me now go to the regional perspective. Of course, I cannot speak for the experiences of the other state parties within the Asia Pacific region. So I will, of course, limit my presentation with respect to our own Philippine setting. I would just like to note, of course, that in the Southeast Asia region, or especially those belonging to the Association of Southeast Asian Nations, out of 11 countries which form part of ASEAN, only 3 actually acceded to the Service Convention. And that aside from, of course, the Philippines, Vietnam, and Singapore. Again, as I mentioned, the reason why I had to cite the rulemaking power of our Supreme Court, because in implementing the Hague Service Convention on the service abroad of judicial documents and civil and commercial matters, it is the Supreme Court. It was the Supreme Court that came up with the guidelines for the implementation of this service convention. But take note, even before the Philippines acceded to the service convention, in a resolution dated December 4, 2018, the Supreme Court already named the Office of the Court Administrator as the central authority for the service convention. By the way, I would just like to introduce myself. I forgot to say that I am Raul Villanueva. I am the court administrator of the Supreme Court. So that means that similar to Mr. Kwang, as he mentioned earlier, everything passes to me insofar as judicial documents in civil and commercial matters are concerned for purposes of being served to the proper parties. And of course, on May 4, 2020, the Philippines deposited its instrument of accession to the Hague Service Convention, and this took effect on October 1, 2020. Again, even before the effectivity of or the coming into force of the Service Convention in the Philippines, the Supreme Court already came out with these guidelines for its implementation. That's how proactive our Supreme Court is. Now let me go to the salient and take note. When we talk about the salient features of Administrative Order number 251-2020, which was approved by the Supreme Court of the Philippines, in a nutshell, the provisions of these guidelines actually proved that even after more than 5 decades, the Hague Service Convention stood the test of time. There was nothing that was included, or at least many of the provisions in our guidelines that were included were taken from the provisions of the Service Convention, which was more than 5 decades ago that was formulated by the Hague Conference on Private International Law. So the scope, as mentioned already by Mr. Brody Warren, covers only judicial documents in civil or commercial matters. It does not include those involving criminal cases. For obvious reasons, because criminal cases, they all have to be within the territories of the Philippine archipelago. Anything that covers or involves that essentially will have to be within the confines of the territorial jurisdiction. Likewise, with respect to grounds for objecting to requests, this can be found. The provisions in our guidelines can also be seen in Article 13 of the Service Convention, wherein there are only two grounds to object to the service or to the compliance of the request. One is when the service does not comply with the provisions of the Hague Service Convention, and second, when the compliance with the request would infringe upon the sovereignty or security of the Philippines. So in this particular case, those two grounds were also adopted by our Supreme Court. Going now to some definition of terms for a better understanding of what this Service Convention is all about, especially as we implement it in the Philippines. First, when we talk about the central authority, as mentioned earlier, the Office of the Court Administrator, which I head, is now the designated central authority for the Philippines. Second, with respect to forwarding authorities, take note, all our justices of the appellate courts, not the Supreme Court, but the appellate courts, the third-level courts, and the judges are considered as forwarding authorities. So that's how high we have placed the designated officers for purposes of forwarding especially the returns, the certificates of service that need to be forwarded to the requesting state. Likewise, when it comes to competent authority, again, the judicial officers involved, many are the second-level court judges in the Philippines, numbering about 1,300. With respect to extrajudicial documents, these extrajudicial documents refer to private or public document not directly related to any pending matter before any jurisdiction abroad. So this means that these are not covered by our guidelines, and these are supposed to be handled by our Integrated Bar of the Philippines or the Association of lawyers in the country, not by the judiciary, because they are not related to any case pending before any foreign jurisdiction. Likewise, there are two requests that are covered by our guidelines. First, the first request is with respect to what we refer to as outbound requests for service. These are requests from our own courts going to foreign countries, whether involving cases before any court or tribunal, of course involving civil or commercial matters. And the other kind of request is what we refer to as inbound request for service. This is the one that is covered by our guidelines, wherein the request will have to pass through the office of the court administrator. Take note, there are some jurisdictions and there are some countries or state parties to the convention that do not charge fees for the service of inbound requests. In our case, however, we have to charge $100 for that purpose. First, in order that the documents we transmit to the forwarding authorities can be served to the concerned parties, and then for them to make the return or submit the certificate of service to the requesting state. So it entails a bit of a cost. That's the reason why we are charging $100. And well, in a way, this affects the service of some of these requests, because if the amount of $100 is not included in the request, then we cannot implement it in the meantime. And just to give you a simple illustration of how these inbound requests are being handled, like I said, the judicial documents coming from the requesting state are forwarded to the Office of the Court Administrator. There is something there that is not included in the illustration, and that is sometimes these requests are actually coursed through our Department of Foreign Affairs, Office of Consular Affairs, which I think Mr. Warren mentioned a while ago, can be used sometimes as an alternative route for purposes of serving. However, that's only for purposes of these documents reaching the Office of the Court Administrator actually. Because the Department of Foreign Affairs is not the central authority. That's why what they have to do is to bring these documents coursed through their office to the Office of the Court Administrator. And then, of course, it goes to a second-level court judge, or sometimes it depends on the kind of documents that need to be served. It may go to an appellate court, depending on whether or not they can help us serve the judicial documents. And once it is served, there is a return. That's the certificate of service that Mr. Warren was mentioning a while ago. The return is then forwarded directly to the requesting party. It does not pass through the Office of the Court Administrator anymore. So the only role of the Office of the Court Administrator is a one-time incident wherein we are the ones that will refer the service to our forwarding authorities. Let me just come up with some statistics for all of you. We have, for purposes of carrying out our role as the central authority for the service convention, we established what we refer to as the Service Convention Unit in the Office of the Court Administrator. So we have a lawyer who is in charge of that particular unit, and she maintains actually the email address for purposes of all of these transmittals. Just for the record, the email address that we are using is phca _service@judiciary.gov.ph. So based on our statistics, since we only acceded and the service convention came into force only in October 2020. So since that time, October 2020 up to August 2023, we have a total of 1,626 requests that the Office of the Court Administrator received. Out of these requests, 1,184 were actually served. So the percentage insofar as these requests are concerned is about 73.4%. Why is it not 100%? Because later on, there are some external and internal challenges that we have to deal with. That's why we cannot make it 100% compliance with the requests. And on the number of at least the top 10 countries that have been requesting for us to serve some judicial documents involving civil and commercial matters come from the United States and Canada. The two countries alone account for about 50% of all the requests that are being sent to the office of the court administrator. And what are the kinds of cases where these requests are being made? This involve either divorce, so family court matters, and of course, estate proceedings involving succession or inheritance. So the challenges and issues, there are only two, basically. One is external. For example, payment has not been received by our service convention unit. The address sometimes is not complete. And then sometimes you also have to deal with a number of, so many actually emails being sent to our office inquiring about how to go about this particular service convention, how to avail of it. And likewise, we also receive queries from non-state parties regarding the service convention, whether or not they can avail of the same. So all of these things will have to be attended to. And of course, sometimes there is no return or email address of those making the request, which makes it difficult for us, for our office, to be able to revert back to them and find out, and get more details about the request. Now, going to the implementation of the Hague Conventions on Judgments and Evidence, although my topic is not supposed to cover the judgment convention, so I will not discuss it extensively, especially because this was previously taken up by the previous presenters. All that I want to say is that for both judgment and evidence convention, the Philippines has not yet acceded to these conventions. However, again, considering how proactive our Supreme Court is, while waiting for us to be able to accede and join the implementation of these conventions, our Supreme Court issued 2 resolutions for this year, in this year alone. In January of specifically on January 24, 2023, the court noted the request of one of our bar associations that we already accede to the Judgment and Evidence Convention. So the court, of course, cannot just do that on its own because, as I mentioned earlier, this is the function of our executive branch first, and then second by our legislative branch through the Senate. But second, a more important resolution was approved by our Supreme Court last February 21, 2023, wherein before coming out with the dispositive portion of the resolution, they recognized the following. First, we are a member of the HCCH. Second, we have not acceded yet to these 2 conventions. Third, that there appears to be a necessity now. The Supreme Court itself determined that there is a need to improve mutual judicial cooperation with other states, and likewise, the need for judicial accessibility and efficiency and responsiveness to the practical needs of the time. I think this is in light of the adoption of a document plan, the blueprint for which all of our actions now are focused on, and this is what we refer to in the Philippines as the Strategic Plan for Judicial Innovations 2022 to 2027. So the court decided to first create a technical working group to study the propriety and feasibility of amending the existing rules of procedure and evidence, gather suggestions to determine possible amendments to the rules of court that might incorporate, that may involve incorporating some of the provisions of the Evidence Convention and the Judgment Convention. And second, because like I said, we need Congress to ratify these conventions before this can come into force. That's why the Supreme Court referred the Hague Evidence and Judgment Conventions to the Senate of the Philippines for study and appropriate action. let me end by noting that during the past few days, there were so many suggestions moving forward to the next perhaps 130 years of the HCCH, which included, among others, of course, addressing disputes over jurisdiction and cross-border issues, increasing membership and enhance global participation of the members, and deepen cooperation among them. So let me add some more food for thought. First, I agree with the comment earlier by Mr. Warren that there is a need to increase the awareness of electronic facilities and automated mechanisms, wherein, of course, even the use of smart cell phones or gadgets can already be used to serve some of these judicial documents. I think there is a need really because the Service Convention, among others, has not yet been amended at all. No review at all has been done, wherein it has to be attuned already to the times, especially because of the world that we're in right now. And second, talking about trees, the HCCH tree that Secretary General Christoph was promoting for us to nurture and, of course, ensure and protect, which is a responsibility of all the members. I am reminded of the poem of Joyce Kilmer, Trees, if you remember, the last two lines, and I quote, "Fools like me, poems are made by fools like me, but only God can make a tree." End of quote. What do I mean by this? What I'm saying that is, thank God that the HCCH tree is not a creation or does not need divine providence for it to exist, but rather what I'm trying to convey is that it would be foolish for the entire HCCH community to let the tree wilt, to render it weak instead of sustaining its growth and making it stronger for the next 130 years. So with that, I would just like to say, long live the HCCH, and as we say it in the Philippines, mabuhay ang Hague Conference on Private International Law. Thank you very much. Mabuhay po kayo lahat.
Thank you so much. Well, 300 years just sounds perfect, right? Thank you so much. Well, thank you for such kind words and warm greetings to all of our guests here. Thank you so much. Well, let's continue with the regional perspectives. Now, let's welcome to the podium Ms. Fan Ho Hung. Please.
Good afternoon, distinguished guests, speakers, ladies and gentlemen. I think that it is a big challenge for me to be the last speakers. Even yesterday we have very big and delicious dinner. So let I join with Raul to share with you our point of view on regional perspective of two important conventions, Service Conventions and Taking of Evidence Convention. So I would like to take this chance to introduce to you Vietnam's outstanding milestone under HCCH framework. So you may see that we joined the HCCH in 2013, and we also the member of three conventions, which are Adoption Conventions, the Service Conventions, and Evidence Conventions. And we have been doing many work to effectively implement this convention. And now I would like to share our experience in accessions and implementation of the Service Convention and the Evidence Convention. Let me give you an overall picture of Vietnam on mutual legal assistance before we joining these two conventions. You can see that from 2008 and to 2016, we received and sent out more than 3,000 requests per year. Although at that time we had 70 bilateral agreements, but 80% of the requests were sent out through diplomatic channels, and only 40% of the requests got the reply. The time to receive a reply lasts more than 9 months. And one of the main reasons for this situation was the lacking of an effective international legal basis for MLAs between Vietnam and foreign countries. So we decided to go to a comprehensive solution, which were acceding to the HCCH Multilateral Convention on MMA. So that's why we became the members of two conventions. That is Service Convention and Evidence Conventions. And when I look back up to now in ASEAN countries, only 2 member countries are the member of the both convention is Singapore and Vietnam. Before we joining these two conventions, we have done many preparation work in order to active implement when we became the member. We study and determine our needs and the domestic situations, which including the conditions for effective implementations. We also study the convention very carefully, and we learn experience from member states. At that time, we received many support from some member states like the US, Switzerland, and France. And especially, we also review and assessing our domestic law in comparing with the requirement of the convention. And to implement these two conventions, we issue a legal normative document in which we include into it many provisions and the template of the service conventions. We are also strengthening the capacity for the central authorities. We try to studying, gathering, and updating practical information of member states in order to make the instructions documents for competent authorities. We are also establishing networks and directly communicating with the central authorities or contact persons of member states, which we sending out many requests. And now we are trying to develop an electronic database for record management. And here's our results of implementations of the service conventions and taking of evidence conventions. As the taking of evidence conventions come into effect to Vietnam just for 2 years, the time of the COVID-19. So the request sent out is not much, just 26 requests. And actually, we don't have many practice experience on implementing the taking of evidence conventions. But for the service convention, you can see that from 2016 to 2022, we sent out nearly 7,000 of requests, and we got 5,800 replies. It's about 84%. So in comparing with only 40% before joining the convention, you can see the big difference. And about the time for serving is from 1 to 4 months only. Before, it lasts more than 9 months. And I'd like to share with you some of our experience in the COVID-19 time. At that time, we faced with many difficulties due to the closing border of the own countries. But we still work on the conventions. We contact with the many central authorities of many member states, and we propose to apply the transmission of the request through the email. And luckily that we received many cooperations of the central authorities of different countries. And the result is that task force of outgoing and incoming requests have been processed and transferred on time. So it was very meaningful for the cost in Vietnam, because the cost still solving their work. So from our experience, joining these two conventions bring us a lot of benefits. So the rate of the reply request has improved, and the time for serving is very short. And it is a motivating factor for Vietnam to enhance our domestic law in compliance with international standards. It also provides us multilateral legal basics to establish the MLA's relations with many countries in the world. It helps us saving sources and time in comparing with negotiating and signing bilateral treaty with many countries. And for the recommendations, I say the same observations with our previous speakers. And also we have some recommendations for the member of Asia Pacific regions. I think that we should allocate more resources and times for learning and joining HCCH and the HCCH convention as well. We all know that when sending out or executing the foreign request, they are all contribute to the supporting competent cost to solve the case, which related to the individuals or organizations in the countries. So why don't we make use of the advantages of these two conventions? It is no cost, it is simple and very effective. So we should make use of these conventions. And for the Asia Pacific member states, which are the member of the Service Convention and Taking Evidence Convention, we think that we should have more activity in the region to promote for the effective implementation of the conventions. Last month, when we visit Germany, we know that in Europe, the LMA's central authorities of EU member states, they meet frequently every 2 months to review the implementations of the MLA request, and they have very good network in this field. So I do hope that for the Asia Pacific countries, we can learn this experience to improve the effective operations of the conventions in Vietnam also, and in the region. And for the HCCH, we do hope that you will provide more technical assistance for studying and promoting HCCH, as well as supporting for the operation of the HCCH conventions in the region. And I would like to take this chance to share some of my personal thinkings. So this year marks 130 years old of HCCH and 10 years old of Vietnam as a HCCH member. So for me, my last 10 working years closely connected to the HCCH and these two conventions. Actually, I was the person who submit the ratifications of Vietnam to join these two conventions. So it is really meaningful for me to attend this meeting. This wonderful and truly PRI environment. So I would like to take this chance to express my gratitude to the HCCH Permanent Bureaus, Mr. Bernasconi, he isn't here now, and their sponsor for giving me the chance to meet many distinguished PIL experts and our dear colleagues from all over the world, and allowing me to share some experience, achievement of Vietnam's under HCCH framework. I think that it is so happy if you have the chance to share the thinking, the experience, the achievements in working with your friends who understand you. So I'm very happy today. Thank you so much, and I wish you all very healthy and happy. Thank you.
Thank you so much. Such sweet wishes. Thank you, Ms. Hong, for joining us. And thank you both for this very wonderful discussion. And thank you, Mr. Warren, for joining us online. So now, ladies and gentlemen, without further ado, it's lunchtime. Shall we conduct the Q&A session during lunch break? Thank you very much. Thank you both. Thank you for our wonderful panelists. Thank you. All right, ladies and gentlemen, we prepared you with a light lunch on the first floor. So please enjoy your lunch break. And a kind reminder for the ladies here, please bring a jacket or just a shawl. Just bundle up for this afternoon, because Hong Kong's air conditioning never lets you down, okay? Thank you. That's my personal advice. All right, so our guests applying for Law Society CPD points, remember to stay until the end of today's sessions to sign out at the reception. Thank you very much. And our afternoon session will be starting at 2:30 p.m. So I'll see all of you again before 2:30 p.m. today. Thank you very much. See you later.